Part 2. The Environmental and Social Impact Assessment of the Bishoftu International Airport on Trial, when paper compliance reflects narratives instead of lived realities. Every mega-project needs a shield. For Abusera Airport City, that shield is called the Environmental and Social Impact Assessment, the ESIA. On paper, it promises safeguards, mitigation, consultation, compensation. On the ground, families are already gone. This is where the story changes. Because this Part 2 is not about intentions, it is about evidence, and we put the ESIA itself on trial. 7. What the law actually requires. Under Ethiopian law, an ESIA is not optional. Environmental Impact Assessment Law requires that any project with significant environmental or social impact must identify affected communities before implementation, conduct meaningful public consultation, assess displacement, livelihood loss, and cultural harm, propose concrete mitigation and resettlement plans. Crucially, assessment must precede action, not follow it. The FDRE Constitution goes further. Article 40 confers farmers and pastoralists the right to obtain land without payment and protects farmers against eviction. Article 43 guarantees the right to development. Article 44 affirms the right to a clean and healthy environment. Article 39 recognizes the collective rights of nations and nationalities, including the Oromo, to self-government and control over land. These are not policy suggestions. They are constitutionally recognized unconditional rights and internationally accepted fundamental rights. They are binding laws. 8. What the ESIA claims. ESIA language. Minimal displacement. Adequate consultation. Livelihood restoration. The Abusera Bishoftu International Airport ESIA makes 3 central claims. First, that affected communities were consulted. Second, that displacement will be limited and compensated. Third, that livelihoods can be restored through monetized frameworks. On paper, everything is balanced. But the law is not satisfied by paperwork. It is satisfied partially by process. 9. Consultation without consent. Consultation, under Ethiopian law and international standards, is not a briefing. It is not a one-time meeting. And it is not conducted after decisions are already made. Free, prior, and informed consent, FPIC, means communities must have the power to say yes or no before land is taken. In Abusera, residents report learning about the project only when surveyors arrived. Meetings, where they occurred, were informational, not deliberative. Documents were not provided in a fan Oromo. Women, elders, and pastoralists were underrepresented or absent. Consent was presumed. Silence was interpreted as agreement. That is not free, prior, and informed consent. That is an administrative theater. 10. Displacement by fraction. The ESIA minimizes displacement by slicing it into phases, plot by plot, house by house. What disappears is the cumulative harm. Farmland loss breaks food systems. Water access is disrupted. Grazing routes vanish. Social networks collapse. Indigenous Gada-based structures dismantled. Compensation, when offered, is often delayed, undervalued, or tied to compliance. Cash cannot replace land where land is life. Livelihood restoration plans rely on assumptions, not realities. Land is presumed as commodified assets. And once land is gone, return is impossible. 11. Cultural erasure is not mitigated. The ESIA treats culture as incidental. Sacred sites are mentioned or shortlisted briefly incidentally. Indigenous place names are undocumented. The Gada system, recognized by UNESCO, is absent. Language loss is not measured. Indigeneity to the land is ignored. Group rights as an Oromo is disregarded. Identity erasure is not mitigated. International law is clear. UNDRIP prohibits relocation that destroys cultural survival. The African Charter protects people's relationship to land. These harms cannot be offset. Once erased, they are permanent. 12. Who bears responsibility? This project is not funded in isolation. Multilateral banks and development finance institutions impose safeguards of their own. African Development Bank, U.S. Development Finance Corporation, export credit agencies, all require genuine consultation, resettlement planning, and grievance mechanisms. Failure to enforce these standards is not neutrality. It is complicity. Financing without accountability transfers risk from investors to farmers, from project owners and their urban elites enablers to unrepresented indigenous peoples. 13. The verdict. Measured against the law, the ESIA fails. Consultation was inadequate. Consent was absent. Displacement began before safeguards. Cultural loss was ignored. Mitigation was theoretical. This is not sustainable development. It is paper compliance masking structural dispossession. By design, the EAL constructed Airport City in a strategically important part of Oromia only serves as a tool to enforce a singular pan-Ethiopian, Amharic-dominated state. 14. A different path. Ethiopia can build airports, but it must also build trust. Development without justice creates instability. Infrastructure without consent breeds resistance. The question remains, does Ethiopia truly need this airport city? Now, here, and at this cost? And if it does, will it finally choose law over force? The land is still speaking. The world is watching. The process of identity erasure began at Birsa Goro, Wara Abebe Tufa, Wara Tufa Muna, and the old airport, spread to Bole and has now advanced to Wara Abu, approximately 40 km from Finfini.